Welcome. My name is Brooke Colaizzi. I am chair of the Labor and Employment Department at Sherman and Howard, and I am joined this morning by my outstanding associate and colleague, James Korte, to bring you a bit of a twist on a presentation that we have done repeatedly over the years, the Big Five. If you've been able to attend in years past, you may have attended the Big Five. It was our refresher primer on federal employment laws, and this year we're switching it up and we're doing a Colorado edition. And part of that is because for decades and decades, Colorado was utterly unremarkable in the realm of employment law. And we simply did not have anything on the books that was different in any significant way from federal employment law. That is rapidly changing. Some of the new laws in Colorado and some of the new laws coming down the pike are some of the most progressive and employee-friendly laws in the nation. So things are changing. We've also found that over the years, because of the predominance of federal law in the employment arena, many clients are not as up to speed as they want to be on Colorado issues. So our goal today is to walk through the major Colorado specific laws. There's more than five. And to try to give you an idea of the quirks, the nuances, the things to keep in mind. We have a lot of material. We may not be able to get to your questions, but please put them in the Q&A. We absolutely will get to each and every one of them after the seminar, and please don't hesitate to do that. So I will go ahead and kick things off. James, if you want to advance the slides, please. Great. We're going to start off with Colorado's Anti-Discrimination Act, or COTA. It's a statute that's kind of an amalgam of a lot of different protections, including the Colorado versions of the main protections under Title VII, ADA, and ADEA. And the important things to recall or to remember about COTA is that it is not limited by employer size the way the federal statutes are. Every employer in the state of Colorado is covered by COTA. Every employee has protections under COTA, with the exception of domestic service for now. And I'll make a note at this point that we have a piece of legislation that is working through the Colorado General Assembly this session that would bring some incredibly fundamentally amazing and different changes to COTA, and certainly will create some unique challenges for employers. I will touch on that statute a little bit, or prospective statute a little bit later on in the presentation. For now, I'm going to walk you through COTA as it exists right now. So there's no limits as there are under federal law. COTA has some relatively unique protections. It explicitly protects sexual orientation. We learned from John Doran this morning that by Supreme Court decision, we now have sexual orientation and gender identity protection under federal law, but COTA has protected those classifications for years. We also have actionable harassment requirement that there is an internal exhaustion of administrative remedies. So not just a charge filing process, but a requirement that employees attempt to resolve the matter within their organizations. And that's one of the things that might be changing with this new legislation. Next slide, James. COTA prohibits discrimination based on marriage or engagement to a coworker for some of the larger employees in the state of Colorado. There are some exceptions for conflicts of interest, some exceptions if employees are within a certain reporting chain or are in sensitive positions, but otherwise, relationships, marriage and engagement relationships within the workplace are protected from discrimination under COTA. COTA protects wage discussions, and this is one that comes up a lot because employers often want to keep there from being significant conflict in the workplace because people are discussing wages, or they might be discussing wages with incorrect or inaccurate information. But those discussions are absolutely protected under COTA, with the caveat that an employee may talk about his or her own wages or engage in conversations with other employees who are discussing their own wages. Clearly, you still can prohibit unauthorized access of wage information by one employee. You don't have to allow that employee to go access everybody's wage information, but the conversations back and forth are protected. And COTA also has some interesting limits on age discrimination. One of them is that compulsory retirement between 65 and 70 is appropriate and can be allowed if there's immediate pension rights. This doesn't come up too often, but it's something to be aware of if you have individuals in those circumstances. CADA allows for a reasonable and consistent dress code explicitly. We often deal with dress codes under federal law, but they are often questions of fair treatment. It can be gender specific. CADA's requirement only is that the dress code be applied consistently. And CADA has religious entity exemptions, both for the hiring of individuals of a particular religion, and it exempts religious entities completely from the definition of employer unless they raise money through taxes or public borrowing. So actually a little bit more protective of religious entities than federal law. Next slide, please, James. Some of the issues on this slide are some of the most unique to CADA. We have a reasonable accommodation requirement for pregnancy, childbirth, and related conditions. This whole issue under federal law is a bit of a mess following the Supreme Court's UPS decision, because the whole notion of reasonable accommodation in large part is still reserved for disability and religious issues. But we have a specific requirement under CADA that these conditions and situations be reasonably accommodated. And an important thing to keep in mind under Colorado law, unlike federal law, employers do not have unfettered discretion to choose among the various reasonable accommodations for pregnancy, childbirth, and related conditions. If leave, it has to be the last option. So if there is a reasonable accommodation short of actual leave from employment, you have to choose that reasonable accommodation and not leave from the workplace. Our lawful activities statute, lawful off-duty activity statute is part of CADA. You may have heard of this statute in the context of medical and recreational marijuana, and the question as to whether employers can take action against employees who use marijuana, notwithstanding the fact that it is legal under Colorado law. The existing Colorado Supreme Court precedent in Colorado is that yes, you still can limit marijuana in the workplace because it remains illegal under federal law. That is certainly one area that could change at any point in time. And so, keep your eye on that. CADA also provides job protected leave for situations involving domestic violence. This piece of CADA has been on the books for quite a while. And we'll see it surface again a little bit later in the presentation because it is also part of the Healthy Families and Workplace Act, or HFWA. And we'll talk about that here in just a bit. Next slide, please. As CADA exists right now, there is a 6-month limitation on filing a charge with the CCRD, the Colorado Civil Rights Division, to go through the exhaustion process before filing a lawsuit. We're used to what federal law requires, which is a default of 180 days, which would be similar to the 6 months. But in most states, it's actually 300 days because of work sharing agreements between the EEOC and state agencies. So typically, we're dealing with a 300-day requirement. Currently, the law under CADA is 6 months. And this is an interesting piece to keep in mind if you ever have the unfortunate luck of having to litigate a case under CADA. Unemployment findings, so the hearings you have, the facts that are exchanged, are explicitly protected from being binding on any kind of subsequent litigation, which is a kind of a unique little quirk, but one that can be very important. So the upshot there is to keep in mind in the context of unemployment decisions that they may be used in subsequent litigation, but they are not binding on subsequent litigation, which can be helpful to know. So at this point, I'm going to turn it over to James, and he is going to transition over to the Equal Pay for Equal Work Act.
Hi, everyone. As Brooke said, my name is James Korte, and I'm going to start off today talking about the Equal Pay for Equal Work Act. And I know Carissa this morning, if you guys were in the morning session, spoke briefly on this topic as well. But what the Equal Pay for Equal Work Act says is that an employer shall not discriminate between employees on the basis of sex by paying an employee of one sex less than the rate paid to an employee of a different sex for substantially similar work. And substantially similar work is defined differently under the Equal Pay for Equal Work Act and that there is no mention, as compared to the federal law, of similar working conditions or establishment. What it does say is that regardless of job title, and that based on a composite of skill, effort, and considering shift work and responsibility, those are the considerations in defining what substantially similar work is. But what does sex mean? Sex is defined simply as an employer's gender identity, which is a simple definition with broad ramifications and for employers. How does one know what employees' gender identity is? That is a great question, and I'm not sure I know how to define that at this point. But moving on to the wage rate. So we have defined sex. We have, what is substantially similar work. What is defined as wage rate? So the wage rate is defined as for hourly employees. It is the hourly compensation plus the value on a per hour basis of all other compensation and benefits received by that employee. That is a little bit more difficult than a salaried employee, where it is just the total of all compensation and benefits received by the employee from the employer. And that's not entirely different from the federal law, but one thing that is substantially different than the federal law and parrots more of what California has done with their equivalent of the Equal Pay for Equal Work Act is a set definition or a set number of factors that an employee can use to justify a pay disparity between sexes. And this is different because the federal law had always had this one factor, and it is any factor other than sex that an employer could use as a defense in justifying a pay difference between different sexes. Colorado, under the Equal Pay for Equal Work Act, now has these 6 defined factors that the employers that employers have to be able to show that any pay disparity is due to one of these. And it is disputed whether whether the employer can have multiple bases or whether they can only have one. So that is a huge difference in the federal law and the Equal Pay for Equal Work Act. Now, what can't you do under this law? And as Brooke discussed with Korte, a big part of this is preventing the use of wage rate history, and also prohibiting employers from preventing employees from discussing their wages with other employees. Essentially, what this law is attempting to do is open up the bars between employees, so employees are able to identify whether they're being paid less in the first place, whether there is any discrepancies in pay. And another part is to prevent an employee, as I think many statistics have shown, for example, is that women often do not negotiate their wage rates while men do. And so if you eliminate an initial wage rate discussion for a prospective employee, this law is attempting to, and we'll talk about this with the posting requirements as well, is start all the employees off on an even footing as far as wage discrepancies go. And so moving on to that posting and record keeping requirement, and this is an interesting one because what the law says is that employers must post in notice for all known opportunities for promotion prior to the promotion decision being made. And these postings must include a range of compensation and benefits. And what it also says is that employers must keep employment job description records and wage rate histories for each employee 2 years after their employment ends. And so you may be asking yourself at this point, what is a promotion opportunity? And it is defined very broadly in that if there's any vacancy in an existing or a new position that an employee could interpret as a promotion in terms of compensation, benefits, status, duties, or access to further advancement, that must be a posted promotion. And so you take that to the extreme and you say, must I post for a CEO position? The CEO is leaving. And I think that the answer right now is yes. However, does that mean that you have to consider all employees for that vacant CEO position or any promotion? And the answer to that is no. So if you have an employee who is up for a specific promotion, yes, you have to post that. Are you required under this law to consider other employees? The answer is no. What is the cost of getting it wrong? So you can get fined under this law anywhere from $500 to $10,000 per posting or record-keeping violation. So you can imagine that if you have a significant amount of postings that you failed to post for jobs, that fine can that dollar amount can increase pretty quickly. And what it also says is that there is a failure to maintain records may also result in a rebuttable presumption that the records would have shown what the employee is claiming. And that would include a jury instruction if it got to trial. And so that is fairly significant, and the fines are fairly significant as well. So this is, and I don't think I mentioned this, I'm sure Carissa did in the morning, but this is already applicable. This law has been in effect since January 1 of this year. And so if there are any questions about whether, as an employer, we're doing this correctly, please talk to us, because it is a very important, and you can see the risks can be significant. So I'm going to toss it back to Brooke to talk about the Senate Bill 176.
Thanks, James. And I mentioned before that we have some legislation working its way through the General Assembly that could have some significant impacts on the laws that we've just discussed. And as often the case with legislation, it changes. So unfortunately, our bullet point list is a little bit out of date as the bill cleared the Senate and moved over to the House with some amendments. So if you have something handy, take some notes on the current version of this bill. And the changes that it could bring are, like I said, really, really significant. So first of all, the original bill did remove the administrative exhaustion requirement, meaning there was no charge requirement for filing with the CCRD. Currently, that has been removed from the bill, but obviously it's something that could come back. And that would mean that we'd have a lot more cases going straight to litigation rather than possibly getting resolved through the administrative process. One piece that is not on here that is incredibly important is this bill would remove the severe and pervasive or severe or pervasive requirement for actionable harassment. So if you've had cases under federal law, you're familiar with the harassment having to be severe or pervasive. That would no longer be the case if Senate Bill 176 becomes law. And that just obviously simply opens up far more conduct to potential harassment claims. Another hugely significant change that would come from this bill, it would treat independent contractors and their employees as employees for purposes of the anti-discrimination laws in the state of Colorado. So your independent contractor who comes in to, for example, repaint the interior of your facility could potentially bring harassment, discrimination, and other types of COTA-covered claims against you, even though that entity is an independent contractor. That is unbelievably significant, almost mind-blowingly so. And if this does in fact become law, please keep your eyes out, because we will have lots of publications and likely seminars on that piece, because employers are going to have to start rethinking these relationships and taking some additional steps to try to limit that liability. Senate Bill 176 would also add a marital status and a caregiver status protected classification to Colorado law. Now, I mentioned before that marital status or engagement status with respect to a coworker is already protected under COTA. This would extend it to marital status generally, not just in the coworker context. And caregiver discrimination long has been kind of an offshoot of gender discrimination. A lot of times these cases popped up as arguments that, for example, women were discriminated against because they often had caregiving responsibilities as opposed to men. This would make caregiver, male or female or anything else, protected under COTA as a separate classification. Senate Bill 176 would also create liability on the part of an employer simply for failing to initiate an investigation of a complaint. You know, obviously a failure to investigate has long been something that can hurt an employer in litigation, but this would actually make it an unfair employment practice. So much like retaliation, you wouldn't necessarily have to have a legitimate or proven claim of harassment or discrimination. If you fail to investigate, that in and of itself can be a violation. Senate Bill 176 would change the charge filing time. So we talked about the 6-month charge filing that currently exists under COTA. This would move it to 300 days. So that wouldn't more or less mirror what we're used to under federal law, but it would change it for purposes of these Colorado claims. And this is another piece that luckily is not part of the bill at the moment. It was once upon a time, and that's the prohibition on confidentiality provisions in settlement agreements. You may recall, kind of in the wake of the Me Too movement, there were attempts by legislatures to limit the ability to put confidentiality on settlement agreements of sexual harassment claims. This is kind of a similar provision, although it would extend beyond just sexual harassment. That piece was removed in amendments in the Senate, but it still has to work its way through the House and go through the amendment process there. So we don't know what will happen ultimately. So please keep an eye on this. We likewise will do everything we can to keep you updated on it, but it could significantly change the law as we know it in Colorado. So I'm going to move over now to Healthy Families and Workplaces Act, or HFWA, which at least for me has been a substantial part of my practice for quite a while. The statute has had profound implications for employers and continues to be a source of administrative headache and difficulties as we struggle to get it right. And kind of to set the context here, HFWA was passed in July of 2020, so right in the middle of the pandemic. A little bit under the radar, because at that point we were operating under the federal FFCRA, which provided paid sick leave and an extension of family and medical leave for COVID-related reasons. But this got passed in July. Through the fall, the CDLE went through the rulemaking process, and we had regulations that were finalized in November. The problem that we ran into is both the statute and the regulations really addressed a scenario where we started paid sick leave January 1, and then it had provisions for a new public health emergency. Sometime in the future, if we had another COVID-like situation, we had provisions related to that future public health emergency. Well, what ended up happening is a few days before Christmas, the CDLE issued emergency rules that declared we have regular paid sick leave starting for our larger employers, 16 employees or more, on January 1, and we are also declaring that the public health emergency provisions are triggered as of that date. And it was somewhat of a tortured analysis in how they got there, but that's the upshot of what was declared. So we had a situation where both paid sick leave and public health emergency leave started on January 1. And what has been difficult for employers in a lot of scenarios is the regulations just really don't fit that particular scenario in all circumstances. So we've been struggling to kind of figure out how we make this work for 2021 with an eye towards, what we will want to do when the pandemic is finally over. And in 2022, when this becomes applicable to the smaller employers in the state of Colorado. So generally, what HIFRA requires is two different types of leave: paid sick leave, or PSL, which is up to 48 hours a year for a full-time employee, must be accrued at a rate of at least 1 hour for every 30 hours worked, or it can be given in a bucket. And which choice an employer made in 2021 actually turns out to be fairly significant in terms of what your obligations are. And I'll talk about that a little bit more in a minute. Usage is capped at 48 hours a year, but carryover is allowed up to 48 hours. So let me walk you through how this works. If you have an employee who has 48 hours of leave this year, doesn't use any of it, come January 1, 2022, they will have their full 48 hours that they can carry over. They are also entitled to a new accrual of 48 hours in 2022. So you could have employees carrying balances of up to 96 hours. However, in any given year, you only have to allow employees to use 48. So I think this was designed so that at least after this initial year, a lot of employees would have some sick leave to rely on at the very beginning of a year before they started accruing. But as an employer, please keep in mind that you can cap the usage of PSL to 48 hours, even if they're carrying a larger bank because of the carryover. Next slide, please, James. So these are, back one. Back one, James. Can we go back one, please? Or forward? I guess we're, sorry. Forward to the boxes.
I'm sorry, my computer is frozen. Brooke, can you hear me?
I can hear you.
Let me see. Are you getting anything?
I hear you, but the slide's at the wrong place. Are we able to advance to slide 17?
I'm attempting to do so. Okay. I apologize, everybody.
Great, that's it. Perfect. Thank you. Okay, so these are the 5 reasons for which an employee must be allowed to use PSL, the regular paid sick leave. Of note are the middle box, the purple box, and the black box there at the end. So paid sick leave can be used by victims of domestic abuse, sexual assault, and criminal harassment for leave from work that relates to those circumstances. So court appointments, therapy appointments, medical treatment, relocation needs, a lot of the same reasons that we have an existing domestic violence leave policy. However, this provides paid leave for those purposes. So keep that in mind. And then finally, we have also PHE closure of place of business or a child's school or place of care. So this is obviously something we became very used to during the COVID pandemic. And this would be a reason why the public health emergency leave that we'll talk about here in a minute can be used, but it is also an explicit use of paid sick leave. So also keep that in mind. Next slide, please. Okay, so let's move on to the second type of leave that is guaranteed by HIFLA, and that is the public health emergency leave. This was a leave that was started on January 1 by the emergency rules issued by the CDLE. And this is related specifically to the COVID-19 public health emergency. And would also be available should there be a public health emergency declared for some other reason sometime in the future. So the effect that this leave has is it requires for a full-time employee, and I'm going to talk in the context of a full-time employee. Part-time employees are covered as well, and there's rules and the regulations for how you calculate their leave entitlements. But for ease of reference, I'm just going to refer to full-time employees. On the day of a declaration of a PHE, full-time employees must be bumped up. Whatever leave provisions they have, whatever policies you have, their available leave must be bumped up so that they have at least 80 hours available that can be taken for the public health emergency reasons, and we'll get to those in just a moment. So, for example, you have someone who gets their 48 hours of paid sick leave at the beginning of the year. They use a little here and there. On the date the public health emergency is declared, you take whatever balance they have and you add to it so that they have 80 hours that they can take moving forward. It gets a little bit complicated after that because you're then administering essentially two banks of leave. Any of the supplemental leave that is given in this, in the case of a public health emergency, is not subject to the same 48-hour rollover process that we talked about with PSL. It exists in perpetuity until 4 weeks after the expiration of the PHE. So that leave has to be continuously available until used or until the expiration of the PHE. And what this basically means then, as an employer, you need to be paying attention in the case of a public health emergency as to why the employees are taking sick leave. And you have to pay attention if it's a PSL reason, or if it's a PHE reason, or if it's a reason that qualifies for both types of leave. After the PHE is declared, paid sick leave accruals and carryovers still continue. So I talked a minute ago about a situation where you give your 48 hours of leave ahead of time. For some employers who have decided to accrue at the rate of 1 hour for every 30 hours worked, when that PHE is declared, the balances get bumped up to 80 hours, and any unaccrued sick leave that the employee would continue to get under regular PSL through the rest of the year continues to accrue. And the 48-hour carryover as applied to that PSL also continues. So you can see that there's quite a bit of administrative record keeping involved when we have both PSL and PHE operating simultaneously. The regulations also make clear that for a reason that qualifies for both PSL and PHE leave, so for example, if an employee themselves becomes ill with whatever the underlying condition is triggering the PHE, their leave is deducted from their PHE supplements first, and then you move into the PSL to deduct remaining time. So again, you're going to have to keep track of why this leave is being taken. Next slide, please. Okay, so here are the reasons for PHE leave as opposed to PSL. And a lot of these are the reasons we become very familiar with during COVID. Employee becomes ill, employee is seeking a test or a diagnosis. They have a family member that needs to be taken care of. Work or businesses have been closed by public health authorities or by the employer due to circumstances related to the underlying health condition. Vulnerable employees can take PHE leave if they're not able to work because their vulnerability to the underlying health issue for the PHE makes them susceptible to becoming sick. And then again, caring for a child or a family member whose school or daycare is closed are all reasons why the PHE leave can be taken. Next slide, please, James. So I want to talk for a minute about the use of a PTO policy for the HIFWA requirement. So this is something that I think has looked attractive to a lot of employers. The regulations allow you to use existing leave policies and programs to cover your HIFWA requirements, provided all of the requirements of HIFWA are met. So the accruals, the rollovers, the documentation requirements, which we'll talk about in a minute, and all of those requirements have to be built into your policies or added to them. But if they are, then you can use your existing policy to cover your HIFWA requirements. And the PTO policy is kind of the most common example. And I think employers really like this idea, but it does create some additional problems that you have to be aware of up front if this is the route that you decide to take. So according to the regulations, if you are going to use your PTO to cover the HIFWA obligations before any request is made for leave under HIFWA, you have to give employees a written notice that complies with the regulations, which essentially, it's got several pieces to it, but the upshot of it is, hey, we're using our PTO policy to comply with HIFWA. All of HIFWA's requirements are built into this policy. You have all of the same protections. You're protected against retaliation, those types of things. If PTO, in a normal environment where we do not have an active public health emergency, if PTO is exhausted, so you give an employee 80 hours of PTO, they decide to take a lengthy vacation and exhaust their PTO, you do not have to provide them with additional sick leave should they become ill or something else that triggers one of those regular PSL reasons. However, if an employee has exhausted the entirety of their PTO bank, they are still entitled to the additional 80 hours triggered by the declaration of the public health emergency. So hopefully we won't see another PHE for a very, very long time. But should we see something, you'll have to keep in mind that your PTO policy will have to be adjusted upon declaration of that PHE. Next slide, please, James. Thank you. So documentation. Documentation under HIFWA is extremely difficult, and it makes it even more difficult to administer the law because you have to keep track, right, of why people are taking leave. Is it a PSL reason? Is it a PHE reason? And you do not have the latitude with documentation that we're used to in with other laws, ADA accommodation or FMLA leave or the like. So for regular paid sick leave, you are not allowed to ask for documentation of that leave until the absence is at least 4 working days. At that point, you can request documentation that supports the reason for that leave. However, if for whatever reason the employee is having trouble getting it from their healthcare provider, an employee writing simply declaring that they are taking leave for a HIFWA reason is sufficient to meet their documentation obligation. You cannot restrict the leave based on the failure to get documentation, and you cannot deny leave for failure to comply with any notice procedures or documentation requirements. So this is not terribly helpful in terms of getting documentation, particularly if you're trying to document reasons or if you're trying to take, tax credits, for example, that exist under the FFCRA. It's not helpful when you can't get documentation. It's even worse for public health emergency leave. For public health emergency leave, you cannot require any kind of documentation at all to support the need for that leave. So what this means is, as an employer, you need to have some good training and practices internally to try to at least verbally get information from employees as to the reason for their absence so that you can do your best to document and keep things separate in terms of why people are taking leave. Next slide, please. Employees may request documentation once a month as to how much leave, PSL or PHE they've accrued and how much they have used, which is another reason why it's important to keep good records internally. And just a reminder that the regulations require you to keep the PSL and the PHE buckets separate in terms of where you're deducting the leave. And so, again, even with the PTO policy, there isn't any current exception for PTO policies as to that allocation requirement. So you need to do the best you can to keep really good internal records on that. Next slide, please. So I'm gonna transition and say just a word now about family. If you have questions on HIFWA, we have had tons of questions on it over the last few months. They tend to be fairly complicated questions and applications. So please drop them into the Q&A and we'll do our best to get back to you on those. A quick word on family, the Family Medical Leave Insurance Program. This is something that had been tried by legislation for several years and had never passed. And by voter initiative back in November of 2020, we now have a Family Medical Leave Insurance Program, or FAMLY, that is going to provide paid family and medical leave to employees in the state of Colorado. This sounds a lot like the federal FMLA. However, they're basically unrelated in terms of eligibility requirements, who's covered, when coverage kicks in. So the reality is, in a couple of years, when this actually goes into effect in terms of the leave provisions, we're going to have to essentially manage this completely separately from FMLA. We don't have a lot of detail on how this is going to work because right now all we have is the language of the voter initiative, which is not very detailed, as you can imagine. But the upshot is that there will be 12 weeks of leave with an additional 4 available for pregnancy or childbirth. There'll be wage replacement percentages based on a fairly complicated formula. The premiums are going to be split equally. So employees and employers 50-50 right now on the premiums. And those premiums kick in January 1, 2022. We certainly hope that we have the regulations before that. but keep that in mind that those premiums are going to start being collected first of the year. And then there'll be reemployment rights. So this is job protected leave after 180 days of employment. So this is going to be another extremely significant program that employers are going to have to navigate. We're still a couple of years out in terms of the actual leave provisions becoming effective, but it's not too early to put it on your radar for figuring out how this is going to work when the time comes. James, I'll turn it back over to you now. Thank you.
Thank you, guys. And I'm going to apologize in advance because the technical difficulties that we experienced a little earlier are still apparent on my side. It appears that everything's working with the slides and everything, but I'm flying blind on clicking through. But we will work together on this and make it through. So I'll be talking about the comps order. And as you all may know, we've been under this new comps order, either the 36 or the 37 since March 16th of last year. Prior to that, Colorado had a wage order. The difference between the comps order and the wage order, or one significant difference, is the application to employers. And under the wage order, you had 4 specific industry categories. But under the comps order, it applies to all employers unless they're specifically excluded. And that can be whether specific types of employees are excluded under rest and meal breaks, overtime exemptions, things like that. But generally, the comps order applies to all employers except for state employers. So exemptions, and these exemptions will apply to minimum wage, typically overtime, rest and meal break requirements, but they're fairly similar to the same requirements or the same exemptions as the federal, but they are defined slightly differently. So you have what you've probably seen under the FLSA is white collar exemptions for administrative executive professionals. One note on the difference between that and the federal, the comps order and the federal law is that an administrative employee must directly serve the executive and regularly perform duties important to the decision-making process of the executive. Another one that you have in the comps order, another exemption, is for highly technical computer-related occupations, and they must be paid at least an hourly rate of $28.38. Other exemptions are outside salespersons, owners and proprietors, interstate transportation in certain categories, and certain in-residence workers, among some others. So moving on to time worked. So time worked is generally defined under the comps order as including all time that he or she is suffered or permitted to work, whether or not required to do so. And under the comps order, there's some employers may be familiar with a defense that's often used under federal law, which is called the de minimis exception for de minimis work, and that's small tasks here and there that are sometimes not considered time worked. Under the comps order, you don't really have a de minimis exception, which means if a work activity takes a minute, the employer must pay the employee for that time. And these can include donning and doffing of work gear, receiving or sharing work related information, emails, voicemails, things of that nature. Security or safety screening, going through a metal detector, perhaps, and other similar activities that may not seem like time work, but in fact are considered time worked. As you'll see on the slide, you have a new travel time provision, which requires that the employee be paid for time spent traveling. That does not include commuting time, though. And sleep time, unless an employee's shift lasts 24 hours, sleep time is considered time worked. So how does the comps order require employers to calculate overtime for their non-exempt employees? So time and a half is due to non-exempt employees for 40 hours worked, hours worked over 40 in a week, hours worked over 12 hours per a workday, or hours worked over 12 consecutive hours without regard to the start and end time of the workday. And the employer will decide which overtime calculation most benefits the employee, and that is the calculation that they will use. And we also have special overtime rules, and there are in some of these rules go back to the exemptions for specific provisions in the comps order. And so one of those is there is no overtime requirement for automotive salespersons and mechanics or employees that earn a commission. The 12-hour overtime rules don't apply to ski industry or medical transportation or the medical transportation industry working 24-hour shifts. And then finally, you have the 8 and 80 rule for hospitals and nursing homes. And what this means is that if the hospital or nursing home has an agreement with employees to pay overtime pursuant to the FLSA's 8 and 80 rule, employees are, which means employees are paid 1.5 the regular rate for any work performed in excess of 80 hours in 14 consecutive day period, and for any work in excess of 8 hours per day. Rest breaks. So rest breaks are not necessarily a new thing, and employers are required to authorize and permit, and that is important language, a compensated 10-minute rest period for each 4 hours of work. And why that language is important, the authorize and permit, is because employers are not required to force employees or ensure that they are taking a rest break. And in certain industries and certain workplaces, that looks differently. For example, if you have a manufacturing line where you have a set rest period, where the only way to take a rest break is to stop the line, then that is more inducive of having a set rest period for all the employees on the line. However, in a lot of workplaces, you don't have that. And so employers are just required to authorize and permit an employee to take that 10-minute rest period. And a failure to provide that rest period is considered a failure to pay wages, not merely a missed rest break. And so in the same vein as rest periods, we have meal periods, and meal periods are different from rest periods as they do not have to be paid. But the employer must provide a 30-minute uninterrupted and duty-free meal period for if an employee works 5+ consecutive hours. And I just dealt with this actually. If it is impractical to not provide an uninterrupted duty-free meal period, the employer may provide that the meal period be consumed on duty. But the difference between that is this is going to be time worked. So this, if the employee is required to take an on-duty meal period, that is considered time worked as if it was a rest, similar to a rest period. And a meal period, finally, must occur at least 1 hour after the start of an employee's work period and at least 1 hour before the end of their shift. moving on to uniforms. Employers are not permitted to require a security deposit for a uniform. If a particular uniform is required as a condition of employment, the employer must pay for the cost of the purchase of that uniform, the maintenance of it, and the cleaning, except if the uniform is plain and washable without special care. And the cost after a return of that uniform, the cost the employer is not permitted to deduct any wear and tear of that uniform. And finally, I wanted to discuss the posting requirements for the comps order. And as I hope everyone knows that you are required to post the comps order poster in an area frequented by employees and where it may be easily read during the workday. And I know a lot of times now we have all gotten very comfortable with a remote work environment. So if a physical posting is not practicable, then the employer should provide copies of all of the required postings within the employee's first month of employment, and each time that an employee may request it. And I just wanted to make one last note is that if you are in an industry where or your workplace has a lot of non-native speaking English speakers, then you can request a translation from the CDLE, but you are required to provide employees with posters that they can read. So I just wanted to turn it back over to Brooke to discuss, sorry, I'm looking, data privacy. Thank you all. I hope that works smoothly since I can't see anything.
Well done. It looked good. We have 2 short topics left, so we're coming up on our time, so this should work out well. Briefly wanted to cover data privacy. Obviously, data breaches, cyber threats are a huge topic and a huge issue. Some employers don't know, however, that we do have data privacy laws that require them to take certain actions if they maintain certain information within their organizations. So for public and private employers that use personal identifying information, and you can see in the slides and in your materials, the definition of PII, you must have a policy for the destruction and proper disposal of both hard copy and electronic documents that contain that PII. Next slide, please. If you are the owner or licensee of computerized data and there is a breach, you have notification obligations. You have to let the folks know who were subjected to or whose information was part of the breach. You may also have to notify the Attorney General or the consumer reporting agencies, depending on how many individuals were affected. So you obviously should have policies and procedures in place for doing that in the unlikely and hopefully never occurring event that you have a breach. Next slide, please. So personal information, the obligation to notify in the event of a breach applies to personal information, which is different than personal identifying information. So your slides contain both definitions. And this is the definition that you can see here of personal information. It's broader than the definition of PII. Next slide, please. And finally, an entity that owns, maintains, or licenses PII must implement reasonable security procedures and practices to protect it from unauthorized access, use, modification, disclosure, and destruction. And what processes and procedures you have to have depend on all of the circumstances. So your size, the nature of the information that you're keeping, your business ops, and the like. So that's not particularly helpful because it can vary so much. But employers do have some leeway in these policies based on their circumstances. So data privacy obviously is an enormous topic, and we raise it so that it can be on your radar if it hasn't been, and that you can work on the policies and procedures you need if you're covered by these obligations. So James, back to you to wrap it all up with Ban the Box.
Yes, I'm sure most employers have heard of ban the box in Colorado. It is now a thing. And employers with 11 or more employees, it is currently effective, and it becomes effective for all employers on September 11th, 2021. And what it says essentially is that employers may not advertise that a particular person with a particular criminal history, or in general a criminal history, may not apply for a position. You may not place a statement in an application that a person with a criminal history may not apply for a position. And you may not inquire about an applicant's criminal history on an initial application. What it does allow, however, or I should say, it doesn't prevent an employer from obtaining an applicant's publicly available criminal background report at any time. It also has an exception for when a job requires, or by law, a job requires certain people not work there with a certain criminal background or criminal history. And so, laws where that prohibit a person who has a particular criminal history from being employed in a particular job, that is, this law does nothing to prevent an employer from following that law. With that, I think I can't see the time either, but Brooke.
Yes, we're up to our time. We know there are lots of questions in the Q&A. Hold tight, we will get to those as soon as we can after the seminar. A lot of them require more time than we could probably give to this anyway, because they can be complicated. So please hold tight. We will get back to you. Thank you for your time and attendance, and enjoy the rest of the session.
Thank you, everyone.